When two or more entities are bound by a contract, and one of the parties bound to the contract violates the terms of within the contract, a breach of contract has occurred. A breach of contract by one party may cause damages or losses to the other parties that are bound to the contract. An entity that suffers loss due to breach of contract can seek redress in court by suing the violator of the contract for monetary damages. Now here's where it gets serious. These are the four types of damages. 1. Compensatory damages. 2. Consequential damages. 3. Punitive damages. And 4. Nominal damages. Let's begin with compensatory damages. Compensatory damages are awarded to entities that suffered a direct loss due to a violation of the terms of the contract by another entity. In other words, compensatory damages are damages that compensate the non-breaching party for the wrongful acts of the breaching party. Compensatory damages are calculated by determining the difference between what was promised by the entity according to the terms of the contract and what was actually performed. For example, let's say I own a fertilizer manufacturing company called Grow Magic. Nitrogen is a vital component of fertilizer, and Grow Magic contracts a local chemical company called Nitro Valley to supply nitrogen gas for production purposes. The terms of the contract say that Nitro Valley will supply 5 tons of nitrogen gas each week at the rate of $5,000 per week. If Nitro Valley fails to supply nitrogen gas in the week because its workers went on strike over unpaid salaries, and Grow Magic has to source nitrogen gas from a much more expensive foreign supplier at the rate of $15,000 per week, Grow Magic has the right to seek compensatory damages from Nitro Valley for breach of contract. In this case, the compensatory damage would be $10,000 because this is the difference between what Nitro Valley promised would be performed and what was actually performed. Let's go on to consequential damages. Consequential damages are also known as special damages. These are damages that are known to the parties involved to be a consequence of breach of contract. With consequential damages, the breaching party is aware that its failure to meet the expected performance as stated in the contract will cause it to be liable for monetary damages. Let's go back to my example of Grow Magic and Nitro Valley. Let's assume that, like before, Grow Magic contracts Nitro Valley to supply nitrogen gas weekly. However, the contract states that Nitro Valley must supply nitrogen gas to Grow Magic by 12 p.m. every Friday, or else Grow Magic will experience severe disruptions to their production process that cause it to lose $2,000. If Nitro Valley fails to supply nitrogen gas by 12 p.m. on Friday, as stipulated by the contract, Nitro Valley is liable for damages, and Grow Magic has the right to seek consequential damages for violation of the contract and loss occurred as a result. We've talked about compensatory and consequential damages, but let's talk about what nominal damages are. Nominal damages are awarded when a breach of contract does not actually cause the non-breaching party any financial loss or damage. A business entity may be involved in a case of breach of contract where the entity does not actually suffer any loss as a result of breach of contract, but still seeks for damages to be awarded regardless in order to prove a point. A judge can choose to award nominal damages to a non-breaching party that suffered no loss in order to indicate wrongdoing by the breaching party. In my example with Grow Magic and Nitro Valley, let's assume that they had a business agreement similar to the previous examples, where Nitro Valley supplies Grow Magic with nitrogen gas on a weekly basis. Like before, Nitro Valley fails to supply nitrogen gas to Grow Magic as a result of an internal worker strike at Nitro Valley. Grow Magic may be able to quickly adjust and source nitrogen gas from another company that offers products at similar pricing to Nitro Valley, thereby not having an impact on Grow Magic's production process of fertilizer or causing financial loss in the course of doing so. However, Grow Magic may still choose to seek nominal damages from Nitro Valley, regardless if Grow Magic did not suffer any actual financial loss or damage. It should be noted that nominal damages are typically relatively very small and can be as low as $1. Before we go, I want to touch on punitive damages. Punitive damages are generally penalties imposed by government or law enforcement officials. Since punitive damages are usually issued in criminal cases and contract law mainly has to do with civil cases, punitive damages are not normally involved in contract disputes. Punitive damages are not applicable to breach of contract cases unless a tort has been committed by any of the parties or a law has been broken.